Alrighty. Starting with the original charges. One account of PC 2309, felony evading law enforcement on a vehicle. Resisting arrest. Reckless driving, drug cultivation were both removed. Additional charges by the DA's office. PC 1128, obstruction of justice. PC 2232, assault on a public servant. PC 3102, reckless endangerment. PC 3108, possession of stolen property. PC 3112, fleeing eluding law enforcement on foot. PC 3130, illegal possession of drug paraphernalia. PC 3207, possession of illegal contraband. And PC 3305, operating a vehicle without a valid driver's license.
What were the two charges that were dropped?
Reckless driving and drug cultivation, due to the circumstances of which those charges do not apply.
All right.
Have what?
So, Mr. Blackstone, let's begin with opening statement, please.
Your Honor, just a brief housekeeping matter before we begin.
Yes, what's going on?
Just for clarity, I don't think we've received a ruling on the expert witness being permitted to qualify for the state.
Was this under the previous judge?
It was, yes, Your Honor.
All right, give me 1 second.
Who's this guy over here on my other side? I never met him before.
The expert witness you're talking about is Miss Lunetta Contarini?
Yes, Your Honor, the basal expert.
Is she here today?
No, Your Honor, I tried making efforts to reach out to her.
Okay.
I don't know her number, so.
All right.
And she
therefore,
wasn't.
she is not here today, and she will not be. Just because you own a restaurant and you know the ingredients does not make you an expert in botany. So she's not here today. She will not be testifying. So let's go with opening statements, please, Mr. Blackstone.
Yes, Your Honor. On September 30th, 2021, ladies and gentlemen of the court, and Your Honor, this situation that happened on that date was a bit of an unusual situation that brought officers to the freeway there, where there was a car accident that resulted in the death of an animal. And upon further investigations, it was come to find out that supposedly the defendant had planted basil, which through the testimony of the witnesses and expert witnesses today will be shown to be cannabis sativa, or marijuana, basically, in layman's terms. In that situation there, we will be proving today that there was a fleeing, eluding in a vehicle, resisting arrest, and upon that resisting arrest and making attempts to make it hard to apprehend him, obstruct justice. With the assault on a public servant, we'll see that he made threats against officers, was in possession of stolen property, recklessly drove, which falls under reckless endangerment, was fleeing, eluding on possession of drug paraphernalia and possession of drug contraband, and operating a vehicle without a license, based on the testimonies today. That's all, Your Honor.
Time out, ma'am. I'm not a drug user. I don't know where he keeps.
Mr. Hall, Mr. Hunt, can you please keep your client quiet there, please?
I can't say nothing.
Of course, sir. No.
All right, let's.
Not now. Okay.
No, let's proceed to opening statements, Mr. Hunt, Mr. Hall.
Your Honor, the defense does not have an opening
I have opening
Okay.
statement.
All right. If you
I have
would,
one.
unless your client would like contempt of court, which is a very long stay in jail, please ask him to be quiet.
Wait, I want to.
We're going
Can
to
I have-
proceed,
can I-
Mr.
Can I have a
Prosecutor.
timeout? No, just time out, Miss. Can I
no.
get time? I don't understand any of this stuff.
Okay,
I just want to.
wonderful. So what you're going to do is you're going to lower your voice and speak to your lawyers. All right, prosecution. At this time, we are going to get this on the road. If you'd like to call your first witness.
Yes, Your Honor. I'd like to call to the stand Richard Steele, member of the LSSD.
Thank you, Mr. Steele. If you'd come over to your left and get sworn in by the bailiff.
Hello, Mr. Steele. Can you raise your left hand for me? Do you swear to tell the truth, nothing but the truth, under the penalty of perjury, so help you God?
I do.
Okay, you can go ahead and stand over there.
If you just stand to the right of me here, you'll see a little microphone come up, Mr. Steele. Perfect.
Oh, yes.
Fantastic. All right, let's proceed with questioning.
Thank you, Your Honor. Hello there, Mr. Steele, and I do apologize. What is your rank for formalities?
I'm now a captain in the BCSO.
All right, then. Well, thank you, Captain Steele, for making it today. Captain Steele, how long have you served with the Sheriff's Department?
For the LSSD, I believe I was with them for 4 or 5 months.
Okay. Given with the circumstances that happened on September 30th, let's see. Are you an expert when it comes to identifying drugs?
Yes, sir.
Okay. In exhibits D3A and D3B, and given from what the defendant claimed in Exhibit D1 and 2 minutes 6 seconds, is that Basil or Basil, however you want to enunciate it?
Give me 1 second. I'll have to take a look.
So for the court, D3A and D3B show green plants on a median strip between 2 roads.
I'm having a hard time finding this information. If someone could help me out.
It's on the court docket. Court docket, first page under exhibits. It's under D3 Alpha and D3 Bravo, and referencing body cam exhibit C. Oh, sorry, D1. My apologies. At 2 minutes 6 seconds.
I emailed you the direct link.
Thank you, Your Honor. D1 would be what looks to be the herb basil, but the 2 other photographs that you are mentioning, that would be marijuana.
Okay. Alrighty. Thank you for that. All right, and let's see here. Looking at Exhibit D1, is that your body cam?
Yes, sir, it is.
Okay. Alrighty, and then let's see here. Just taking a look here. All right, given with the timestamps there, what vehicle did the defendant state was his?
It would have been the white four-door vehicle that was crashed out just a short distance away from the original scene.
Okay. Did the defendant say that was his car?
Yes, and he also told me that I should have been able to find the documentation for it inside the vehicle along with his license.
Okay. And for the court's clarification, that can be noted at D1 at 3 minutes 7 seconds. Now then, jumping ahead to 3 minutes 24 seconds in Exhibit D1, was the information in Exhibit and at 2 minutes, was the information that was stated at 3 minutes 7 seconds found in the vehicle?
No, there was no note from the individual that supposedly owned it, and his identification was also not inside the vehicle.
So,
Okay.
Mr. Blackstone, can, instead of referring to the timestamp, because that is part of the evidence, would you mind just asking Mr. Steele the direct question?
Yes, Your Honor.
Yeah, just so that instead of him referring to his notes or to his body cam, that he is actually answering direct questions.
Yes, Your Honor.
Okay, thank you.
Alrighty. After finding no information here, was the defendant by 932 Gates, was he going to be detained?
Yes, he was.
Okay. Did the defendant resist being detained?
Yes, he did. He ran back towards his car, got in it, and decided to speed off.
Okay. Alrighty. Now, given your position and expertise as a law enforcement officer, was the defendant driving safely?
At first, he was driving within the speed limits, but then it got to the point that he was not. He was changing lanes. We eventually ended up having quite a few collisions and went off-road as well at high speed.
Okay. Given with that, that's okay. For court's clarification, that's found between 4 minutes 27 seconds and 12 minutes 19 seconds. Okay. Let's see here. Taking a look at some things here. Alrighty. Now, given with that, is that reckless endangerment?
Yeah, there was no regard to ourselves or himself or the property that he had stolen, or anybody else that was on the road for that matter.
Okay. Now then, given with that, alrighty. Did the defendant leave the vehicle?
Eventually, yes. He jumped out of the vehicle, and there was a small foot pursuit towards the end of the encounter.
Okay. Right, and given with that, okay, let's see here. Just referencing some things here real quick. All right, and let's see here. All right, and this is after you had, did you incapacitate the defendant?
Yes, I believe I was the one that ended up striking him with the baton, causing him to go down.
Okay. Did you warn, sorry, did you tell the defendant to stop?
Yeah, there were multiple requests from everyone on scene for him to stop resisting.
Okay. Did he stop resisting?
Not until he was subdued, no.
Okay. And taking this, okay. What station was he taken to?
I believe we ended up taking him up to the Sandy Sheriff's Office, the BCSO, one of our headquarters.
Oh. Now then, so given with the body cam there, did the defendant remain in his cell?
No, he did not. He attempted to escape twice, if I'm not mistaken.
Okay. And given with that, and with the understanding of the law, let's see here, that would be, okay. Was he preventing his apprehension?
Yes. Every time we tried to close the cell door, he tried to keep it open and get out.
Okay. Did he threaten to hit Tyler Gates?
To be honest with you, I can't recall. I've been quite busy here lately. So I would have to review the body cam footage.
Okay. For court's clarification, that's at 29 minutes even.
I understand it's on the body cam, but we're also, the defendant does have the ability to cross-examine Mr. Steele.
Okay. All right then, and let's see here. Did Tyler Gates search the defendant in the cells?
I do know he was searched. I'm not sure if it happened while he was in the cells or prior to. Normally, normally what we do is we search them before we even take them to get medical, just in case something takes place at the hospital. We want to remove everything off of them. Generally, myself, I search whoever I have in custody multiple times. Could be anywhere from 2 to 3, 4 times, just to double check and make sure.
Okay. Was a driver's license found on the defendant?
To my knowledge, no.
Okay. Did Officer Gates pass you items found on the defendant?
Yes, sir. I do remember he was called away abruptly, and he had to leave, so I had to finish the processing.
Okay. What items were found on the defendant?
Do you recall, Mr. Steele?
Yeah, I know that he had some drug paraphernalia on him, 1 or 2 crack pipes. He also had a knife. He did have multiple phones. I remember him saying that he sold phones, and then I believe he had a radio as well.
Okay. Alrighty then. And referencing, oh, never mind. Let's see here. Yeah, referencing back to the car real quick here for clarification. Who did he say that the white car belonged to?
I can't remember the female's name. I would have to refer to the body cam footage. I deal with a lot of people and they give me a lot of different excuses. It's not easy to remember the names.
Okay.
We do look into every one of them, though, when we are given a name for an individual that owns a specific piece of property or a vehicle, and we try to make contact with that individual to double check that they actually do have permission to use it.
Okay. Did the car belong to anybody?
No, it came back unregistered.
Okay. All right, no further questions, Your Honor.
All right, defense.
Good afternoon, Mr. Steele.
Hello.
And just for clarity, when you were stating what was on the defendant, I presume you were, of course, you don't just remember that. You looked at the exhibit?
No, this case is the only one that I have right now that I needed to be present at. So I do recall what he had on him and some of the conversation that we had. The phone stood out to me because it's not often you find someone with more than one phone, and I don't normally hear of people selling them. So there were a few things that stood out.
Okay, so you explicitly remembered exactly what the defendant had on him at the time of the arrest.
Well, I wasn't sure exactly how many crack pipes he had on him. It could have been more than 3. I just know that there were multiple, 1 or 2.
All right, and for clarification, you searched him, right?
I think we both. Gates had searched him first, and then I eventually had searched him at one point as well.
Okay, and let's talk about what you testified to on your direct examination earlier. Mr. Steele, earlier you testified to the fact that you're an expert in identifying drugs, right?
Yes, sir.
And how did you gain that expertise?
Well, we all have to go through training in order to classify not only the effects, but what they look like. Various types, obviously, crack has different versions. You got rock, powder, various liquid type drugs as well. We have to learn how to identify those to do our job correctly. Over the time that I've spent with the LSSD and then now with the BCSO, being farther up north, there's a lot of grow operations that we come across, and there's a lot of people that traffic out in that direction on the highway. So we've gotten pretty good at identifying what the different drugs look like.
Okay, and you said that you originally learned how to do this during your department certified training, right?
Not necessarily during the training. We obviously know what we're supposed to be looking for in the terms of scent and how people act on different intoxicants, but most of it is gathered from all of the drug operations that we do.
Okay, so you're saying because you've been on X amount of drug operations, you know exactly what each drug is.
Yes, basil does not smell like a skunk.
Right. But you'd agree that in your direct examination, you didn't ask how it smelled. He specifically asked you to look at the exhibits and state what those were, right?
Yes, the leaves have different patterns.
The leaves had different patterns, right? So have you seen basil leaves being grown before?
Not in this state, no.
Right. So you don't know what a grown basil leaf looks like, right? In this state?
I guess I don't understand the questioning. I mean, there's a picture of it.
Sure. I'll ask you like this. You've never seen a basil leaf being grown, right?
No.
You don't know what it looks like, right? A basil leaf?
I know what a basil plant looks like. I've never seen it grown in this state.
Right. And in this state, do you know what they look like?
I'm sorry? Do I know what the plants look like?
That's correct.
No, I don't know
Right.
what a basil
So you
plant
wouldn't
looks
be
like.
able to tell the difference between a weed plant and a basil plant because you don't know what a basil plant looks like, right?
That's wrong. The leaves are very distinctive.
Right, but you don't know what a basil plant looks like, so you don't know if it is distinctive
What
to
the
a basil
plant
leaf,
looks like,
right?
if it's going to be 6 feet tall or 2 feet tall, makes no difference. The leaf itself, there's a big difference between the two of them.
Right, and again, I'll go back to this. You'd agree that something could look different in the state, right?
Your Honor, objection. I'm not understanding this type of questioning regarding this situation. It seems like they're just going around in circles.
Your
It
Honor,
seems irrelevant to me.
unless something changed, I don't believe him not understanding is a valid objection.
Correct. What is your objection?
Relevancy, Your Honor. I mean, it's either that or he's trying to coerce the witness into saying something he shouldn't, or is trying to make him.
Okay, so you submitted as state prosecutor 2 pieces of evidence. One is a picture of Basil, which I'm not sure where it came from, but you have a picture of Basil. And then you also have seen photos of what Mr. Steele has said is marijuana. So the defendant is asking if Basil, which has already been established is not grown in our state, how does Mr. Steele know the difference between the two?
It would be the leaves.
Okay. And so therefore the defendant, Mr. Hunt, is asking you, how would you know that if basil is not grown in our state?
Your Honor, for clarification, if he's never seen it grown.
The 2 leaves side by
There's
side.
no question to you, sir. Don't worry.
Okay. So you're going to continue on this or move forward, Mr. Hunt?
Your Honor, what was the ruling on the objection?
It is overruled.
I'll make it brief, and then I'll move on
Okay.
to the next point. Okay, so briefly, have you ever grown plants before?
Yes, I have.
What plants have you grown?
Tomatoes, pumpkins.
That's all?
I mean, there's a large variety of plants that you can
Oh,
grow.
no, that's all right. I was just asking.
I really don't want to go down the list. I have quite an extensive garden.
Sure. And that garden, that's at your home?
Yes, up in Polito.
Okay. And then just to go back on it briefly, again, I don't want to stay here forever. But again, you've never seen a basil plant grown, right? You've never grown it yourself.
That's correct.
Right. So you wouldn't know what it looked like if you did see it, right? In the state.
In the state, no.
Right. Okay. You'd agree that you never saw Mr. Johnson place any plants, right? You arrived on the scene after it had already occurred?
Detective Landmark is the one that witnessed him planting them.
Right. You'd agree that you never saw Mr. Johnson place any plants, right?
That's correct.
Thank you. You'd agree that through the search of the defendant, you never found any weed in his possession, right?
That's correct.
Okay. And to your knowledge, how do you grow weed?
With seeds and soil.
And what kind of seeds do you need?
Marijuana seeds.
Okay. And he didn't have that, right?
That's correct.
Okay. In your direct examination, you testified to the fact that he was running away from you while in the cells, right?
That's correct.
Have you ever in your career as a law enforcement officer charged somebody with obstruction of justice for resisting arrest?
I can't recall every one of my cases. I've arrested a lot of people in this state.
Sure. Do you recall ever doing that?
Once again, I cannot recall all of my cases. I don't know what charge I gave every individual. I have quite the track record.
Okay. You stated earlier that Mr. Johnson essentially interfered with his apprehension, right? That's what you testified to?
That is correct.
You'd agree that at that time he was already apprehended, right?
Until we have them locked in the cell and secured so we can continue the processing, then they are not fully apprehended.
He was in custody?
He was within the cell, but it wasn't locked.
Right, but he had handcuffs, right? He had handcuffs on his hands.
He did it one time. I can't recall if the second time he tried running out, if he had been released or not yet.
Okay, and I'd like to just go over just the charge of obstruction with you very briefly. I can give you a copy of the penal code if you don't have one. Do you have a copy?
I'd have to look it up on my tablet.
Sure.
Okay.
All right, so you'd agree that it states unlawfully hindering the discovery, apprehension, conviction, defense, or punishment of anyone who has committed a crime or of evidence, right?
That's correct.
And how did he hinder his apprehension?
Until we have them secure in the cell, then, we can't continue with the processing.
Okay. And I'd like to go back to a question I asked earlier, but phrase it in a different way. Let me ask you in the form of a hypothetical. Let's say you were arresting somebody in the cells, they started walking away. Do you charge them with obstruction of justice?
I've never had that situation occur, so I couldn't truthfully answer that.
You've never had somebody walk out the cells while you arrested them?
No, most of the people that I've come in contact with, they're compliant.
Okay. Well, let's say in the hypothetical that they did do that. Then what would you do?
It would depend on the scenario, depend on what I was arresting them for, the situation.
Okay. So let's say you're arresting them for drug cultivation. Then what?
If they were willfully trying to keep me from detaining them or arresting them, then yes, obstruction would be one of the charges.
Okay. So let me give another example. Let's say someone gets out the car and they run from you. Is that obstruction of justice?
No, that would be fleeing and evading on foot.
Right. So what's the difference between fleeing and evading on foot between obstruction of justice if it's the same thing that occurs?
I truthfully don't have an answer for that. There's multiple charges that we can apply that have pretty much the same meaning. It all depends on the situation and the officer, really.
Sure. I believe Mr. Hall has a couple questions for you.
I do. Can you state your name again for me?
Yes, it's Richard Steele.
All right, Officer Steele. Now, previously in your testimony, you stated that you searched the defendant. Is that right?
Yes.
Now, previously in your testimony, you admitted that you typically search the defendant a multitude of times in an arrest. Is that right?
That's true. The only time that wouldn't take place would be if I was...
That's all right. I do have another question for you.
Okay.
Now, you have testified to searching the defendant. Isn't it true that you found pumpkin seeds on his person when you searched him?
I would have to look back at the body cam.
So, right now in this courtroom, you cannot recall what the defendant had on his person.
I can only recall the illegal things, the stuff that I actually take off of them and hold. That's the only thing that matters in the report.
Now, when you conduct a search of an individual, isn't it true that you're looking for, number one, everything that they have on them, and number two, items that are material to the case that they are being placed under arrest for? Is that right?
The only thing that I generally look for are the things that could cause harm to myself or others, and then the things that are illegal. Some
Isn't it
people
true
hold
that-
a lot of items.
If I may, isn't it true that even in the instance where a person has a lot of items on them, all of that is evidence? Isn't that right?
I don't agree with that, no. Only the things that pertain to the case I would consider to be evidence.
Okay. You would agree. Okay, so anything that pertains to the case. Now, wouldn't you agree that the defendant having seeds, not of marijuana seeds, but of pumpkin seeds, wouldn't that be material to the case
Yeah.
that you were arresting him for?
Objection, Your Honor. There's no relevancy for this. For the fact is, there's no evidence that shows the pumpkin seeds were taken. I don't know where these pumpkin seeds came from.
Well, Your Honor, if I may,
Yes.
overall, I'm trying to go as to what the officer found on his person. Pumpkin seeds were on Mr. Johnson on the date of arrest. And if the officer can't remember that, I think it's very relevant that he states on the record that he can't remember what was on the defendant.
Once again, the only thing that I can
All right, sir.
recall
There
is...
is an objection pending.
Just wait one minute, Mr. Steele. The objection again, Mr. Blackstone, is in regard to relevance, correct?
Right. For the fact is, it's irrelevant to the case. For the fact is, it's not noted pumpkin seeds.
I understand it's not stated as pumpkin seeds. However, Mr. Steele has said that not only does he plant his own vegetables, which is fantastic, but he also knows about different plants that are planted here in our state. So therefore, he must have a small knowledge of seeds and whether he recalled seeds on the individual or not. So I'm going to overrule and ask Mr. Steele just to answer if he recalls the seeds or not.
I do not recall pumpkin seeds.
Thank
Okay.
you, Mr. Steele.
So, Officer Steele, you're stating on the record that you cannot recall everything that was on the defendant on that day. Is that right?
Only the things that didn't pertain to the case.
Okay. Now, previously in your testimony, you admitted to having lapses in your memory. Is that right?
I deal with a lot of people, and I just was assisting with getting the BCSO started, so I've been pretty neck deep in paperwork and changing SOPs since that incident. So I cannot recall everything.
Okay. So, since you can't recall everything, why should this court take your testimony to mean 100% facts of what happened on that day?
Well, I mean, that would be up to the court to decide if they wanted to take my testimony. The body cam footage, that can't be ignored.
I'm talking specifically about your testimony. If you're having lapses in your memory, why is your testimony credible?
I expect that given my tenure as an officer in this state, that should amount to something.
Again, sir, if you'd like, I can repeat the question. That wasn't an answer to the question. All right.
I
you want
think
me
that my reputation, as well as what I've done in this state, should be enough to make my testimony valid. If that answers your question.
It does not. I'm going to ask my question again for you. All right. Now, overall, you've testified to having lapses in memory, especially on this date in question. Now, with that in mind, why should the court accept what you're saying is the whole truth?
I don't know how to answer. I don't know what you're looking for.
Okay. Now, I'd like, if you could, to reference the body camera footage. I believe it's Exhibit D1 that was submitted. If you could specifically look at, this is going to be timestamp 9:50, and then watch until, let's say, 10 minutes or so, if you could. And then once you finish watching that, if you could describe for the court what exactly happened.
Would you like me to give you a play-by-play, counselor? Is that what you're looking for?
Yes, if you could.
Well,
Your Honor,
as-
objection. This is narration.
In regard to how is it narration?
He's asking to have something stated that was already put into evidence, and they're asking for a summary. And in regards to this is a narration because it's already in evidence. They don't need to tell a story and recount of this. This is narration.
I understand your objection. I really do. However, the body cam footage does belong to Mr. Steele. It is his own, and that he has submitted, under oath through the body cam program. And it is only roughly 10 to 15 seconds long, and Mr. Hall is only asking for an explanation of what happened. I'm going to overrule because I'd like to see where we're going with this explanation. So, Mr. Steele, if you could just summarize what happened there.
Okay. As of right now, we're at 10 minutes 57 seconds. We just came back off of Route 68 and is following the suspect on a police chase through the dirt roads and hills. He's 1050 quite a few times, and we're still pursuing. Some of the other officers also wrecked out while trying to chase him.
I'm sorry. I'm gonna stop you right there. Again, just to specify, the timestamp is going to be from 9:50 to, let's say, 10:05. If you could watch that specific person, I think he watched a different person.
It starts with us being on Route 68 and then venturing off-road out into the fields.
Okay. And is there anything specific that happens in the timestamps that I laid out for you?
Apart from us trying to catch up to him, my vehicle had flipped over, and then I looked at the GPS. Doesn't seem to be much standing out. It's a typical chase.
Okay. Now, you said that's pretty typical for a chase, is that right?
Yep, most of the time when we're involved in a 1080, they generally like to speed and go off-road.
Now, since this is the norm of what's happening in police chases, wouldn't it be safe to say that it's not necessarily inherently dangerous or in any sort of way reckless? This is a day-to-day occurrence?
No, I think that it's still reckless and extremely dangerous. Just because people do it doesn't mean that it shouldn't be any less dangerous.
All right. Now, in the actual the timestamps that I gave you, isn't it true that your vehicle flips multiple times?
Yes.
Okay. Isn't it true that that is an open plain away from any sort of civilization?
I mean, we were on the road there for a little bit. I wouldn't say we're away from civilization. If you watch the footage, you'll see that we've passed multiple stores and people driving.
I'm going to answer in a yes or no. Is that on a dirt path away from people?
At which point in the body cam footage?
At the timestamp that I gave you. You're off on the dirt road.
And
anyone but officers around you guys.
You're saying from 950?
Yes.
Yes, we would be on a dirt road, but we passed by a trailer.
Okay. Now, with that in mind, isn't it safe to say that there is no one around you?
No, that is not safe to say, because past the trailer, you can see a civilian vehicle driving to the right-hand side of the screen.
That's not my question, sir, and that is actually out of the timestamp that I'm talking about. Specifically within that timestamp, is there another person that you can articulate? You know who they are, that they were in danger while this was occurring?
No.
Okay. Now I'd like to back up a little bit to, of course, what you were asked previously by Mr. Hunt. Now, you stated that the charge of obstruction of justice, that derived from when the defendant allegedly ran out of a cell. You had to chase him or corral him back in there. Is that right?
That's correct.
Okay. Now, it's true that he was in custody at that point.
He was in the facility. I can't recall if we had him cuffed or not. You got to realize the body cam footage is 12 days old. I've had a lot going on since then.
I completely understand that. I agree that we've touched on that you have lapses in your memory. But at that point, it's fair to say that the defendant was placed under arrest. Is that right?
I would just like to point out that I don't think it's fair to say that
Sir,
there's lapses in my
please,
memory because of the
excuse me,
amount of
sir.
time that's lapsed.
Your Honor, I'm going to object. The witness at this time is becoming non-responsive. If you could please
Okay, I'm
answer the
going
question.
to ask that you. So, Mr. Hall, first of all, we don't need to reiterate what was already said in regard to lapses. Let's move on with questioning, and
Sure.
so that Mr. Steele can just answer the questions directed at him.
Of course, Your Honor. Now, again, this is all in the cells when you're stating this is what the obstruction of justice charge is for. At that point, the defendant, he was placed under arrest at that time, correct?
He was in the facility. He was already under arrest.
Okay, so he was in police custody. That was a question.
Yes.
Now, with that in mind, who was the defendant interfering with you apprehending, placing into your custody?
I'm. Come again?
So, with Mr. Johnson already in custody, who was he at that point, obstructing you from taking into your custody?
We couldn't secure the cell.
You could answer in a yes or no. Not a yes or no, but give a specific name as to who Mr. Johnson was obstructing at that time.
Both myself and Mr. Gates.
So, in the charge of obstruction, would you like me to explain what the charge of obstruction is for you?
No, it's already. We already went over that with the other counselor.
All right. Now, isn't it fair to assume that in the charge of obstruction of justice, one individual has to obstruct your duties from apprehending another?
Yeah, that's what the definition is.
And since Mr. Johnson was already in custody, what other third party was he obstructing you from apprehending?
There was no third party. Even though he was in custody, he still wasn't fully apprehended, as the cell was open and he wasn't compliant.
You stated that he was placed under arrest.
Yes, and we can state that we're going to detain someone and arrest them and they can still take off running. That doesn't mean that they're still in our custody when they're down the street running over people.
But I do have a question now. The defendant is currently being charged with operating a vehicle without a driver's license. If you could describe for the court how either your office, the sheriff's office, or the DMV keeps tracks of individuals that don't have a valid driver's license. In other words, licenses that are suspended.
We do fingerprints. Once we take their fingerprint, we verify their identity in the MDT and check all of their licensing and verify that we're out.
Okay. Now, isn't it true that the MDT profile or government profile of the defendant was not submitted into evidence?
I believe that is true. I don't think that anyone submitted it for evidence.
Now, again, previously stated that you keep track of individuals whose licenses are suspended in the MDT, is that right?
That's correct.
Okay. All right. Now, I know we touched on, you previously searched the defendant. Now, can you state exactly everything that the defendant had on him?
As I've already testified, I only keep track of what is necessary for the case.
You previously testified to the defendant having, I believe, crack pipes on him, is that right?
That's correct, as well as phones, a knife, and I believe a radio.
Okay. Now, isn't it true that the defendant has been charged with charges that, again, would apply to these crack pipes 2 times, essentially 2 charges that would apply?
Can you repeat the question, please?
Sure. Do you, as an officer, typically charge a defendant with charges that can be applied for the same offense, essentially? If you'd like, I can give you an example.
Oh, yeah, if you would give me an example.
Sure. Do you typically charge a defendant, let's say for possession of a firearm? Do you typically charge them with possession of a firearm, brandishing a firearm, let's say if they have a holster on as well, openly carrying, essentially charging them with 3 separate charges for the same incident in question?
It depends on the situation.
Can you elaborate on what a situation would be?
There's been times where if someone does have multiple pieces of drug paraphernalia on them, if they are compliant, then we may cut them a break. There's times, though, that if it's a severe enough amount, then yes, they will be charged with multiple charges pertaining to the same thing.
Okay. Isn't it true that you testified to Mr. Johnson only having 2 crack pipes on him?
That's correct.
Okay. Currently, the defendant is being charged with possession of stolen property. Do you currently know what property was stolen?
That would be the vehicle.
Okay, how do you know that?
It was reported as stolen and came back unregistered.
Okay. Can you testify for the court who stole the vehicle?
I cannot.
Sorry, who was the owner of the vehicle?
There was no listing for an owner. It just came back as unregistered.
And you testified to there being a call of this vehicle being reported stolen?
There was, however, by the time the entire incident had ended, there were too many 311, 911 calls for us to be able to handle it. There was something going on in the city that ended with multiple 1199s, which can be seen in the body cam footage.
Okay. So it's fair to assume that this call was not actually submitted onto the record?
No, we were unable to get it due to the amount of time that had lapsed.
Okay. Now, I note here as well. I know here as well that there is a Exhibit C. It's named Vehicle License Plate Lookup. Now, without looking at that exhibit, can you recall the plate of the vehicle that the defendant was driving?
No, I cannot.
Okay. If you'd like to look at Exhibit C now, I'd just like to have you point something out for me. Can you describe what you see on this exhibit?
I see a vehicle license plate number with 0 results coming back to it.
Now, typically, if a vehicle was stolen, isn't it fair to assume that it would be marked stolen on the MBT?
Only if it was taken from locals. Or if it was taken from someone that wasn't a local. Sometimes we have people reach out and they let us know that their car has been stolen and we had update it in the MDT.
Okay. Now, on Exhibit C, do you see any markings or anything in general that states that a vehicle has been stolen or that, that the defendant was not the owner?
No, I do not.
All right. Your Honor, I think Mr. Hunt may have some questions. If not, no further questions from you.
Any more questions, defense? All right.
No further questions from the defense, Your
All
Honor.
right. Sorry. Thank you. Mr. Blackstone, was there anything in addition that you need to ask Mr. Steele before we let him go?
Yes, Your Honor. Sorry, I'm stuck between these
That's
chairs.
all right. Those hips don't lie.
Captain Steele, given the situation, for clarification of the court, did you look up the license plate of the vehicle?
Yes, I did.
Okay. Did it come back to anybody?
No, it did not.
Okay. All right then. And with that being said, if it belongs to nobody, yes, someone's driving it, does that mean it's stolen? In your professional opinion?
Objection, Your Honor. I'm going to say that the question calls for speculation. Overall, there's nothing, no evidence, nor does this officer know whether or not this vehicle was stolen.
I am looking back at my notes, and Mr. Steele already said there were quite a few dispatch notifications, too many that evening, unfortunately, to notice if one had been called in stolen or not.
Okay.
So we'll leave it as an unknown.
Okay. We're given with the understanding then, Mr. Steele, do all those who are not locals, when they drive vehicles, oh, let me rephrase the question there because I was going to go on randomly there. Individuals who are not locals and drive their vehicles, those come back to them, correct?
Generally, yes.
Okay. And those that are local vehicles don't come back to people that are not locals.
That's correct.
No further questions, Your Honor.
Thank you, Mr. Steele. I appreciate your time. You are able to step down, sir.
Thank you.
Hey, thank you, Lieutenant Steele, for your time.
Your Honor, I request
Well,
that I be
nice
relieved.
Nice things, right? No?
Yes,
Thank
you
you.
are. Yep, 100%. Prosecution, do you have another witness?
Yes, Your Honor. I'd like to call the stand Detective Frank Landmark.
Mr. Landmark, if you would come to your left and speak to the bailiff. Slowly.
Been a long day.
It has been. Raise your left hand for me. Do you swear to tell the truth and nothing but the truth under the penalty of perjury, so help you God?
I do.
You can go ahead and take a stand over there.
All right, if you just stand next to the big black chair, there should be a microphone right there for you.
There we go.
All right, Mr. Blackstone.
All right. Hello there, sir. For clarification for the court, can you state your name?
Frank Landmark.
Okay. And what part of the sheriff's office do you belong to?
The Major Crimes Division.
Okay. Now then, as a part of Major Crimes Division, you are familiar in identifying drugs, correct?
Correct.
All right. Is Exhibit D2 drugs?
No.
What are the plants in Exhibits D3A and D3B?
Marijuana plants.
Okay. All right. In regards to that, let's see here. Are you familiar with these plants shown in these two pieces of evidence or exhibits?
Yes.
Your Honor, we'd object as to relevance. The state has dropped the drug cultivation charge against the defendant.
Your Honor?
Yes, your rebuttal.
The rebuttal to that is, if, as stated in note 26, I believe, of the penal code, if there are less than 10 plants, it counts as contraband.
One
And this-
moment.
Oh, my apologies. 5 plants or less, Your Honor.
But it also states it needs to be on the person.
In the ground, Your Honor. You got to read the last sentence. The second to last.
But you dropped the drug cultivation.
Correct, because of the previous sentence, because it's less than 5 plants. It says if it's over 5 plants, it's
Okay.
cultivation. That's why contraband is charged, not cultivation.
Okay, give me 1 second. All right, sustained at this point. You may continue.
Oh wait, you're sustaining my objection? Oh, you're you're sustaining the question I asked?
No. I'm sustaining their. I'm sorry. I'm sustaining what you asked. I'm overruling. There's too much going on. Overruling
Right.
their objection. Apologies.
Okay. No, not all right. I understand, Your Honor.
Okay.
So
Sorry, Your Honor,
just
just
for
to clarify,
clarification.
So
what criminal code was being referred to? Just so I can
it's at
reference
the
it?
very bottom of the Title II Criminal Code. It's note number 26.
Oh, I see. Thank you.
Alrighty. Now then.
Yeah, give me 1 second. I'm going to read that out because everyone's going to ask questions. It talks about illegally rolled joints up to a certain amount, but this wasn't for joints. This is for plants. It says, referring to the CDS charges for the Code of Charges, if an individual is possession of bags, he did not have any bags on him, and an officer must blah, blah, blah. Marijuana plants in the amount of 5 or less is considered illegal contraband and should be seized. Any number of potted plants or plants in the ground 5 or more is considered drug cultivation. The plants must be planted in the ground or potted and placed within or on a property to be considered in cultivation.
Thank you, Your Honor, for explaining that.
All right, continue.
Okay. Detective Landmark. Let's see here. How well trained are you in identifying marijuana?
To a standard required to identify.
And looking back at your record here, how long have you served the sheriff's office?
A couple of months.
Okay. In your experience, have you come across these plants quite often?
Very often, yeah.
Okay. So these would be something you could identify on the spot.
At every stage of the plant's life, yeah.
Okay. All right, let's see here. Did you witness the defendant planting the plants in the divider?
Yes.
Okay. What did the defendant say those plants were?
The defendant didn't acknowledge the plants when I questioned him about them.
Say that again. My apologies, my hearing.
That's okay. The defendant didn't acknowledge the plants when I approached him about them at the time.
Okay. All right. What brought you to the divider there on the freeway?
I was responding to a call made by the defendant in regards to his vehicle striking livestock on the freeway.
Alrighty. And let's see here. Just make sure I'm looking at everything here. Okay. Did you look up the plates to the, from what your statement says, a white Buffalo?
No.
Okay. Alrighty, and looking at this here. Were you involved in the pursuit?
Yes, so I initially stayed behind to pick up the plants, speak to EMS, make sure the lane was clear, and then I joined as a tertiary unit on the pursuit, yes.
Okay. Okay, you said you picked up the plants. Okay. Were those plants? Oh, never mind. I'll be repeating. Okay. Let's see. Actually, no. Here we go. After picking up those plants, were you able to positively identify them?
Yes.
Okay. When did you join in on the chase?
Roughly around 5 minutes, the vehicle took off northbound and then passed me again in the opposite lane southbound.
Okay. Did you witness the vehicle going off-road?
Later on in the pursuit, yes.
Okay. Now then, given with the understanding of the law, is that reckless endangerment?
Yes.
Okay. Is the vehicle that the defendant in a vehicle that should be driven off-road?
No.
Your Honor, I'm going to object on the basis of this is an expert opinion by a layperson. At no point has it been testified to that this officer is a mechanic or any individual that would be skilled in knowledge in terms of vehicles or what should or should not be driven off-road.
Your Honor, my rebuttal to that?
Yes.
All officers are supposed to know and identify what vehicles are street-worthy and what are not street-worthy.
Your Honor, if I may,
Yes.
there wasn't any sort of foundational questioning or testimony to support that.
What was your question again, Mr. Blackstone? Whether the
Let's
car
see.
itself, which vehicles?
Right. Whether that vehicle is worthy to drive off-road. Or is that, I believe for my question, Your Honor, I asked, is that car meant to drive off-road? I'm sorry. I'm
The
having
defendant's car or Mr. Landmark's?
the defendant. My apologies. The defendant's car is what I was referring.
Again, I'm not sure if Mr. Landmark is an expert in civilian vehicles.
I can ask a different question
Yeah,
regarding that.
see if you could rethink that.
Okay. Mr. Landmark, or Detective Landmark, given with your professional expertise as a law enforcement officer, that also includes traffic enforcement, is that vehicle a street-worthy vehicle?
Yes, four-door sedan with road wheels, yeah.
Okay. All right then, and let's see here. And given with your professional opinion, did that vehicle evade law enforcement?
Yes.
Okay. And let's see here. And when the car did crash, were you there?
Yes.
Okay. Did the defendant flee on foot?
Yes.
Okay. And given with your expertise and professional opinion, given with everything here, from him getting into his vehicle, driving off, to the long pursuit, to the what is seen in the body cam of running out of the cells, and is that obstruction of justice?
Give me a second just to check the description on the criminal code. So from the body cam described to me, the defendant, when attempting to escape custody, was hindering his conviction or his punishment for the crime, so I'd say that's obstruction of justice, yes, as defined in the criminal code.
Alrighty then. Making sure I'm covering all my bases here. Alrighty then. Let's see here. Now, for clarification for defense and such for reckless endangerment. Oh, actually, never mind. That was already asked and answered. Never mind, Your Honor. I have no further questions.
Thank you, Mr. Blackstone. Defense?
Yes, Your Honor. Permission to approach.
Yes, you may.
All right. How's it going, Detective Lemmer?
I'm not too bad, Oliver. How are you?
Doing very well, thank you. All right. Now, previously you testified to seeing plants in the middle of a highway divider. Is that right?
Yes.
All right. Now, can you describe what time this all took place?
I can't give you an exact time because of the actions inside the scene. I couldn't check my time device or a watch, but it was either late in the evening or early in the morning due to the night.
Yeah, it was nighttime, right?
Yeah.
Okay. So, generally, I mean, I'm sure you can see from Exhibit D1. Wouldn't you agree that it was quite dark out on that night?
Absolutely, yes.
Okay, so it would have been hard for you to see.
For me, no. So my vehicle headlights were on the divider.
Okay. Now, you then testified that you went ahead and picked up these plants in the middle of the road. Is that right?
That's correct, yes.
Now, with those plants, I assume you collected them and put them into evidence. Is that right?
That's correct, yes. The seeds from the plants, yes.
All right. Did those please say seeds or plants or whatever you collected, did those change hands at all, or is that solely in your custody?
Solely in my custody.
Okay. Where is that evidence now?
From recollection, it'd be in the evidence lockers of the Sandy Shores Sheriff's Office.
Okay. Isn't it true that that evidence was not submitted to this court?
Without checking, unknown.
Okay. Go ahead and check the court docket and let me know if you see on there the evidence that you just described for the court.
Your statement's correct, yes. Not submitted.
Now, was that evidence withheld?
I can't recall.
Okay. Did you ever give that evidence to the arresting officer or to the prosecutor?
I can't recall. From the two parties arresting him, myself can't recall now.
So, you cannot recall whether possibly exculpatory evidence was not handed to the arresting officer and the prosecutor and the defense. All right?
Correct, due to the time frame, yes.
Okay. Now, at any point, did you run any sort of scientific tests on the plants that you collected?
None required to identify it already, no.
I'm sorry, can you repeat that?
Absolutely, yeah. None required to already identify it, no.
Okay, so just so I understand correctly, you did not run any scientific tests on the plants that you collected.
Correct.
So, from a scientific basis, you cannot state yes or no as to whether that is marijuana.
Scientific, no. Physical, yes.
Okay. Now, back on the actual scene, you stated that the defendant, he planted these plants and then he ran away. Is that right?
So initially, the defendant planted 4 plants. I walked back towards my vehicle while we discussed. The felony evading started when over 2 call signs arrived on scene and began to question him in regards to the plants.
Now, to your knowledge, does the defendant own that strip of land on the side of the highway? The plants were planted.
To my knowledge, no.
So it's fair to assume that the defendant gave up control of any plants that were in the middle of that road.
I'd say the defendant gave up control as soon as he started evading law enforcement, but prior to that, no.
Okay, so he wasn't in possession of them, right?
Say your question again one more time, sorry.
So he wasn't in possession of those plants, is that right?
After planting them, no.
Well, he doesn't own the divider and the highway, is that right? So he wasn't in possession then, was he?
Once planted the plants in the central divider, he wouldn't have been in possession of the plants, no.
Give me one moment here, right?
That's okay.
Now, you didn't search the defendant at all, did you?
No.
And again, do you have anything to do with the suspension or holding of driver's licenses in this state?
As far as I'm aware, I've not conducted any suspensions or apprehensions of driver's licenses, but if a driver's license is to hit a certain point limit, it can be revoked, yes.
Okay. So typically you'd have to look on the MDT to discern whether or not a defendant has a suspended license, is that right?
So how it normally works is we either acknowledge them either via the MDT for easier work, or we have a system on the laptop in his cruisers that allows a basically license check to see points and licenses of the current individual.
Right. And just to confirm evidence, do you see a copy or lack thereof of any sort of suspension of the defendant's driver's license?
Give me a second. From the exhibit submitted, there is no stating none of the driver's license has been submitted.
All right. No further questions, Your Honor.
All right. Mr. Blackstone, your last and final cross-examining. Okay, those hips.
Yes.
Cut it out.
Can't help it. I inherited him from my dad. So,
Whoa.
dad and my mother.
Okay.
God bless
Jesus.
her soul. God bless her soul.
Okay. Okay. Given with the understanding and definition of the law, Mr. Landmark, this is in question to PC 3305 again. When it says operating a vehicle without a valid driver's license, would that mean, in your professional opinion, that includes not having a driver's license on you?
It could be construed that way, yes.
Okay. All right, and then let's see here. You have permission to ask a scenario question?
In regards to, I mean, this is your final.
Right. It's in regards to PC 3305.
So still in regard to the valid driver's license.
Yes, Your Honor.
Will it be brief?
Yes, Your Honor.
All right, rock and roll. Let's go.
Oh, all right. Detective Landmark, if you were to pull over a gentleman for whatever traffic infraction, and you ask for his driver's license and what have you, and he doesn't have one, would that constitute a violation of PC 3305?
Give me a quick second. It could be construed that way, but it'd also partner up with PC 4125.
All right. So you would charge both of those.
Initially they'd get 4125, and that'd allow me further cars to look into see if they, on my system in the car, actually have a driver's license.
Okay.
Is that your question?
No further questions.
All right. All right, Mr. Landmark, thank you so much.
Class
You
three.
can go and fall asleep on the bench over there.
Thank you.
Prosecution and defense, we are at the time of closing statement so that we can get this all wrapped up and head to Biddy Buys.
Your Honor, unfortunately, the defense does have one witness.
Okay, awesome sauce. Let's rock and roll. Defense, do you have any witnesses?
The defense calls Henry Johnson to the stand.
Wonderful. Mr. Johnson, if you would...
Oh, that's me.
That's you.
That's me.
If you would
Woohoo.
head over to the bailiff, sir.
Oh, yeah.
He's on your left there, and he's going to swear you in. Nope,
No,
that's your
no,
right.
over here, sir.
Right up there.
Over here, sir.
I'm going where?
Right here.
Go right there.
Gentleman,
The man with his hands up.
Yep.
The gentleman in the tactical vest, the khaki one, the brownish
What?
vest over there,
Right
behind you.
behind
We're
you.
going to agree
Behind
to
me,
tell the
oh.
truth.
Right over here. There
Go
we go.
towards the American flag.
Okay. Can
Okay,
you raise
okay.
your left hand for me?
You're doing great, Mr. Johnson.
Doing 100%. Can you raise your left hand for me?
My left?
Lift up
Yes,
your
you are.
hand. Raise
There
it
you
to-
go.
There you go.
Do you swear to tell the truth, nothing but the truth, under penalty of perjury, so help you God?
I don't know what perjury is.
It's where you go to
Um,
jail if you tell lies.
Well, I'm not a liar, and these guys been trying to call me a liar and drug dealer.
Is there,
um,
are you saying yes?
What was
Is
the
that a yes?
question?
Do you swear to tell the truth, nothing but the truth, under penalty of perjury, so help you God?
This is where I say yes.
It's your decision.
That's your decision.
Yeah, I'm not gonna lie. Yeah. Right.
Okay.
Okay, come and
You
stand
can go
next
stand
to
over
the
next
chair.
to the judge.
And you'll see a little microphone right in front of your face there. Just stay still. There we go. Okay, that's my chair. Hello. Okay, Mr. Blackstone, if you'd like to... sorry, not
yeah,
Mr.
honest.
Blackstone. I'm sorry.
Yeah, I was about to
It's
say.
getting
Okay.
late for me. Mr.
Okay.
Hunt is going to ask you some questions.
Okay. This chair is nice.
All right, Mr. Johnson, I'm going to do my best just to keep this as brief as possible, but I recognize it probably won't turn out to be quite that way. But we'll dive right into it. So
Just time out. Just time out. Small words. I don't want to keep asking for definitions. Thank you.
Sure. So on the 30th of September, you were arrested.
Yep.
Can you describe what happened?
So I'm driving to get some pills for Miss Mary. That's her car. Then a deer came out of nowhere and hit her car. So I called 911. And then I felt bad for the deer. You know, no one gave no attention to the deer. So I was like, I'm gonna plant a little bit of food on the side of the road for him. These basil plants. And then the EMS person, I asked for EMS, and they don't even walk up to the deer, and I'm like, you can't just say he's dead. You gotta check for a pulse or something, you know. And then he said, I'm not a veterinarian. I'm like, it's an animal. You can still check a pulse. You don't need to go to school for that. That poor deer. I don't know if it was a mama deer too. It didn't have the horns. And then that mean cop, lieutenant guy, he just started yelling at me. You know, I was trying to get my paperwork out of there, and then he said you're going to jail or something like that. I don't remember. It's a little, you know, past. But then I got in the car and I left. I know I'm in big trouble with that. I didn't hit no car though. I'll tell you that much. I didn't hit not one car because Miss Mary was going to be pissed off because I hit that. Well, the deer hit me, and I know she was going to be more pissed off. You know, so I just got, you know, I didn't hit no car. All right, they're lying. They're trying to paint me as a drug dealer. I don't even listen. I'm 5 days of drinking free, okay? I got my 5-day chip. Ma'am, you want to see my 5-day chip? Ma'am? You want to see my 5-day chip?
No, I don't think it was
So-
entered into evidence. We're good.
Okay, so anyways, they bring me back to the cell here, and I said, you know, I'm scared for spiders. You know, I'm scared. You know, I like had seizures before because I got bitten by one, you know, when I was a kid.
Mr.
So
Johnson, I'm just going to interrupt you
said,
briefly because we're going to get to that. But just to cut it up a little bit, so
okay.
we can do a little smaller word. So you said you planted some food on the ground. Where
Yeah.
did you get that food?
From a friend that said they feed deer. They're like hunters.
Okay, so a friend gave you that food?
Yeah, he's a hunter, but I don't like killing animals. You know, that's why I called 911. You know, that's why I called and see if we could save that mama deer life. I know the difference. You know the difference between a male deer and a female deer?
No.
All right, the male has horns. You know, like these little antlers thingies. And then the mama deer, she don't have no, and sometimes she has udders when she just gave birth. I didn't check her udders because I was trying to give her some privacy. You know, R.I.P. Mama deer.
Okay, and to your knowledge, what was that food that you planted? in the
Basil.
median?
I thought it was kind of weird they like basil, but he said, hey, I give deer corn and some basil, and they go crazy, and they always come. So I was trying to like offer like a sign of peace, so that way I don't go to sleep and then I'm getting beat up by some deers in my tent.
Okay. And you're also being charged with operating a motor vehicle without a valid driver's license. At the time of the incident, if you recall, did you have a driver's license?
Yeah. I mean, you can't drive a car without a license. That's why I've been walking everywhere. Because I don't have my license. I never got it back.
Right. You're also being charged with obstruction of justice. What they're essentially alleging is that you ran away from them while in the cells. Can you describe what happened during that incident?
Oh, that's the part where you said stop, right?
Yeah.
That's the part? Okay. To go back on that part, you writing this down, ma'am?
I'm writing down more than you can imagine.
Oh, you need like a secretary person to write this. But
I would
anyways,
love one, but she didn't show up.
oh, fire her. Oh, all right. Anyways, so I'm afraid of deer. I mean, not deer. Spiders. I got bit when I was a kid. I had a little seizure. So, you know, each time I get arrested, the cops go in there. I don't get arrested much. To be honest, probably like one or twice. But I always had them check the cells with their flashlight underneath the bed, near the toilets and stuff like that, and they always do. Hey, man, can you take your hat off, please? That's kind of rude.
Just keep on with the answering the question, please.
But he got his hat on.
Answer the question.
Okay. Ma'am, that's okay. Oof. So anyways, damn. Oh, stop. So anyways, the spider, they always check the cell, you know, behind the toilet, underneath the bed. And then they say it's clear, and then I double check, and then they lock me in the cell, take my cuffs off, you know. In that case, I told the guy, can you please check the cell? And these guys were being mean and stuff like that. And the dude even said, if you watch his body cam, he said, yo, there's a spider on your head. I'm going to hit you with my baton. Ain't no spider in my head. I definitely would have known if there was a spider in my head. So, you know, and they hit me. They ended up stuffing me in there, and they didn't want to check for spiders, and they put me in a different cell, and they refused to check for spiders. So I kept laying next to the door because I was afraid of a spider might come out. Yeah, spiders are bad, you know.
Mr.
But they're
Hunt,
good. They're good at the
Can
same
we
time.
move this along, please?
Wait, I was talking about spiders.
Sure. Sorry, I'm just going to ask you a couple more questions here. So you're also being charged with possession of stolen property. They're alleging that, of course, you stole the vehicle that was used in the commission of a crime. Can you describe where that vehicle was from?
Yeah. That's Miss Mary's. She live. Anybody got a phone so I can look it up real quick? That's Miss Mary's car. So I do like odd jobs and stuff. So that's why I got like they found a lot of phones and repair kit. By the way, after this courthouse, I'm doing a special 1 for 5, 2 for 10. That's a good deal. 3 for 20. All right. But I do like odd jobs. Miss Mary, I know her go back from church days, and she broke one of her legs. So she said she needed her medication. She ran out. So I went to go get it, and I didn't listen to Miss Mary's directions, and I got all turned up around, and I ended up going the wrong way. And then that deer hit me. So I mean, I got the keys and everything. I don't think that's stealing. Why would someone steal if you got the keys? Why would I call 911
Mr.
if I stole
Hunt,
something?
Are there any more questions?
Yes, Your Honor. Just a couple more briefly.
Okay.
So you're also being charged with assault on a public servant. Do you recall what had occurred for you to be charged with that?
Listen, I definitely didn't hit no cops. Okay, I don't know why he got mad at me. He hit me. If anything, we should be charging him with attempted murder because he hit me twice without me even hitting him. That guy is reckless.
Can you
He
describe what happened during that incident?
Yeah, so the first they hit me that first time that's how they caught me, which I get it. They gotta subdue me. But then I go in the cell and I'm like, yo, can you please check for spiders? Please check for spiders. And then the guy pointed his taser at me, and then the other guy's behind me. And then he said, I'm gonna hit you with the baton. So I turned around real quickly and I was gonna say, who you gonna hit with that baton? I ain't do nothing to you. But then he just whacked me right there. I didn't even do nothing. Just for looking at him. I guess that's why he charged me with it,
So just for clarity, with regard to that incident, you never actually hit any officer, right?
No, I didn't touch not one person. I know better than that.
Okay. And what you're stating is you said that you were simply turning around to tell him, who are you going to hit with a baton, right?
Yeah, because he's not going to hit me. I didn't do nothing to him. He can't hit me like that. That's against the law. Ain't that right, Judge?
We'll find out.
You can't just hit people for no reason. I swear that's against the law.
Any more questions?
I do believe Mr. Hall has a couple questions.
Fantastic.
All right, just to follow up with what Mr. Hunt was saying, Mr. Johnson. Now, at any point did you square up with the officer? And if you'd like, I can do a demonstration if you'd like.
Yeah. I don't know what you young kids say. What you triangle up?
Here.
What?
At any point did you go say like this towards the officer?
I turned around real quickly. It may have looked like that, but I wasn't hitting him or nothing.
Okay. You didn't get up in his face and start threatening violence against him, did you?
No.
Okay. Now go back to the vehicle.
Wait a minute.
Right.
Can we do a timeout real quick? Miss Judge Lady, you got any good food? Cause I'm hungry and I'm thirsty. I'll give you a repair kit if you want.
No, we're good.
I don't believe in free. You sure?
There are some muffins
Okay.
in the cabinet right there. I don't have anything left to drink.
You mind if I drink here? I'll leave a repair kit for you. Okay, nothing
No,
free in
that's
life.
fine. Just grab the
Nothing.
muffins.
Yeah. I'm gonna eat some. If you don't mind, okay.
Perfectly fine.
Can I eat in the corner? Cause I don't like people looking at me when I eat.
No, just hold your hand in front of your face.
Okay.
All right. Now, Mr. Johnson, go back to this vehicle that you were driving. Now you're testing the fact that you were given permission to drive that vehicle, right?
Yeah, I mean, she told me to get her pills. That's why she
You-
gave me the car keys.
You didn't steal that vehicle, did you?
I mean, she gave me the keys, gave me, she was gonna pay me money to go get something for her. I don't think that's stealing.
Okay. And you said previously you were given basil plants. Is that right?
Yeah.
Okay. And if you were planting and any sort of plants, that's what you would have believed you were planting. Is that right?
Yeah, basil to feed the deer. I mean, that poor mama. Rest in peace, right, guys? Rest in peace. She hit my car. You know, at least I could plant a little food for her young ones, because they like basil and corn.
Now, with that in mind, you're also being charged with obstruction of justice. Now, at any point, did you try and break another person out of police custody?
I was the only one down there. Who could I break out? Casper, or maybe the spider in my first cell?
Okay.
Maybe I wanted to break that spider out my first cell, or Casper on the other ones, because there ain't nobody down there but me.
Did you ever lie to any of the officers there, essentially prohibiting them from apprehending another individual?
Listen, I'll tell you this right now, right on the record. You writing this, Judge, real quick? I want you to highlight this, circle, underline 4 times. Henry Johnson is no liar or drug addict or drug user. Highlight it, double stamp it, quotation marks, exclamation point. I am not no liar, Mr. Hunter.
Okay. So, you didn't try and provide, say, false evidence to the officer to, prohibit them from apprehending another person, did you?
What's false? I mean, I'm assuming that's fake evidence.
Exactly.
From catching someone. How could I do that?
Okay.
I don't understand how I could make something. I didn't do nothing. I ain't no liar.
All right, Your Honor. I believe that's all the questions for this witness.
All right, defendants. You're done.
Sir,
No,
sir with the
no,
sir with
no,
he's got a hat on.
No.
He's,
Shh.
wait,
Prosecution, Mr. Blackstone has some questions for you.
what's his name?
Mr. Blackstone.
Blackstone.
Oh, hello, Mr. Blackstone. I'm Henry Johnson. Doing the pink hat. Take that shit off. You in a courthouse? Don't worry, I got
listen.
you, Honor.
Quiet,
Well up your
please.
grandma's house.
All right. How are you doing today, Mr. Johnson?
I'm doing okay right now. I just want this whole process to be over with.
Don't worry. We'll see what can be done. All righty. So, in regards to this, you said this car belonged to a Mary. Do you recall her last name?
Right now it's hard because this guy wearing his hat. I just keep looking at his pink hat.
Just
Mr.
look
Hall,
down.
Mr. Hunt, if you do not control your clients,
But it's kind of
there will
hard.
be, consequences.
No, but he's
Johnson,
wearing.
just answer the questions, all right?
Okay, can you stand in front of him so I don't see his hat? A little bit to the right, Blackstone. A little bit to the right there. Perfect, right there. I don't want to see his hat. There you go.
Okay.
That pretty girl blocked it. I like her. She's good. Okay, what was your question again?
Do you recall Mary's last name?
Mary, I can't right now. For some reason I'm drawing a blank. Once in a while that happens. You draw a blank. When you know something and it's just so much pressure right now. But I don't.
But you make it sound as if you know her very well.
I do. She, church lady, she used to hit me on the side of the head when I used to fall asleep in church.
Okay. Now, you said that you got the car from Mary's house.
Miss Mary house, yes.
Miss Mary's house. My apologies. Where does she live?
If you're gonna quote me, please do it correctly, okay?
Yeah. Where does Miss Mary live?
Well, if you give me a phone, I could look it up. I don't have a GPS on me. You guys took my phone. That's how I make my money. You guys took all 7 of my phones.
Okay. Well, You say you went to church with her, so
Well,
I
I
would
could-
assume you would, and you know
Well,
her very well. You
I'm
would.
one of those guys that I know how to get to it. I don't know the street name. Okay, I don't even know what street I'm at right now.
Okay. You said you were on your way to get her medicine.
Yeah,
Do you realize?
she broke her leg.
Okay. Do you realize that there are multiple pharmacies located throughout Los Santos?
Okay, but we were up in Grapeseed, in Sandy Shore area. That's why I said I took the wrong turn. Were you sleeping when I was talking?
No.
You trying to catch me in a lie or something? Don't.
Why didn't you go to the pharmacy in Grapeseed?
Well, don't quote me if you didn't. I said I took a wrong turn. If you're gonna quote me, at least quote what I said and don't try to make me look like I'm a liar. All right, let's stick to the facts, okay? And don't try to catch someone trying to slipping. I don't like that. That's some con stuff right there. You ever play those?
Mr. Johnson, thank you. That's enough.
Okay.
Any more questions?
Yes. Now, you stated for the court that, referencing Exhibit D1 at 29 minutes, you stated that at this time Officer Steele was behind you with a baton.
Wait, what? Yeah, he was behind me. I mean, you pulling minutes and stuff like I have a tablet in my face and I know exactly what time and stuff he did.
Okay. So you are saying that Richard Steele...
Stop putting words in my mouth and just say it.
Did Richard Steele tell you he was going to hit you with his baton when Tyler Gates was pointing his taser at you?
I said when I was outside of the cell, when I didn't want to go in there, because I said check for spiders. He said there was a spider on the head. You go back a few more minutes and you'll see it. He said it.
Huh. Okay. Now then, regarding with assault...
Are you going to go back and review it?
We're moving on, Mr. Johnson. In regards to this, now then, given the definition of assault doesn't mean physical harm, it can also mean threats of bodily harm. Did you tell Officer Gates, and I quote, I'm going to punch it,
Listen,
punch you in your bald head. Did you say that?
Say it one more time for me, please.
Did you tell Officer Gates that you would punch him in his head? Or as you say, in your bald head?
Did he say I'm going to punch somebody in the bald head, Your Honor?
I do believe
Your Honor,
so.
if we could get an exact, I suppose, reference to what exhibit this is coming
Exhibit
from?
D1, 29 minutes, defense.
I ain't got a tablet. How am I supposed to... Listen, I don't know what I said. It happened 12 days ago. What do you want me to do?
So I make sure you're aware of that. It's in question. It's
What do you
part
mean?
of the charges.
Do you recall it or not?
I got to review the camera work or something.
Do you recall it or not?
Can I look at the camera work? Could I get a tablet?
Hold on.
Your Honor, if you want me to, I can give him my
I've
tablet.
got one in here. Hold on.
Okay.
All right, here you go. Yeah, just look over here.
Okay. What minute? What minute we need to go to?
It starts at 29 minutes even.
All right, I'm watching it right now. I see me being drunk. That's why I'm an AA right now. 5 day clean, Your Honor. 5 day you're clean. I was drunk. What do you want me to say?
Did you say that?
Well, I mean, what do you think? Didn't you watch the same video I just watched?
I just need to hear from you, Mr. Johnson.
I mean, I don't think you need to hear it from me. You watched the same video.
Mr. Johnson, I am about to charge you with contempt of court. You are not You are not answering questions directly.
Okay, I'll answer his question.
The defendant a hostile witness or a hostile.
Okay, I don't even know what that means. Can I answer your question?
State the question one more time, Mr. Blackstone, and move on.
Yes, Your Honor. Did you state that you would punch the officer as what was stated in 29 minutes on Exhibit D1?
Hold on. Hold on.
Mr. Johnson.
Oh, give me 1 second, please. Bald face. That's what I said. You said bald head. You trying to catch me slipping?
No, it's for the fact is you threatened to punch an officer is what I'm trying to get to the point. Did you threaten to punch an officer?
I seen this in Dave Chappelle once. I plead the fifth. 1, 2, 3, fifth. 1, 2, 3, 4, fifth.
Your Honor, I'd like to consider this gentleman hostile at this point.
Let me
Since he's
explain
avoid-
that you waived, when you said that you would be a witness up here, you waived your right to that. So therefore,
I can't-
you answer the question. The question
Oh,
was, did you say that you hit a gentleman in his bald head? You replied with no. I said I hit him in the bald face. Let's move on.
I thought I
Okay.
could plead the fifth up here.
Not anymore, sir. Let's move on.
Oh, okay.
All right. Let's see. Did you have your driver's license on you? On
mean,
this.
I mean,
Sorry.
I can't typically when I drive a car, I always have a driver's license. That's what Mama taught me. You can't drive a car without a license.
That's not answering my question.
I just answered it. I said, yeah, you can't drive a car without a license. That's what Mama taught me.
I was asking you, did you have yours on September 30th in the date in question, in the date and time question?
Yeah, because I wouldn't get in a car without a driver's license.
Okay. Alrighty. In regards to this here, when officers were trying to detain you, why did you walk away?
Walk away because they ain't cleared the cell. They have spiders in there.
No. I'm talking about back at the traffic stop. What brought the officers to you?
I brought him to me. I called because that deer hit the mama deer hit my car.
Mr.
Or
Johnson,
what?
let me ask you again. Why did you walk away at the traffic stop
Because
when they
I
were trying to
seen it.
detain you?
I don't remember, but I seen it in his eye and something just said, "Hey, get in the car, because this guy gonna get you for murdering that deer." When the deer jumped out at me, okay? I don't know how you guys are. That's why I got hit like twice. You guys are crazy. All right.
I'm not an officer.
Oh, I thought you were.
No. I'm a lawyer. I'm a prosecutor. Member of the DA's office. Anyways,
Thank you for your service, sir. America.
in regards to this, again, okay, well, actually, no, I'm going to move on from that. Were you aware what you were planting was marijuana?
It's basil leaf, man. How many times you gonna hear me? You been sleeping? Cause I said it so many times at this court case. It's basil. They like basil and corn.
Who told you it was basil?
My hunting friend. Well, he hunts. I watch, and then I get to get some of the, some of the food. I ain't got a hunting license. Can't hunt.
So you don't know for sure it was basil.
Man, this man never lied to me since I've known him for 2 months. Okay, it's basil.
Okay. All right. Do you have a note from Miss Mary that states she gave you permission to drive that car?
Yeah, let me go back to her house right now and go get that note for you. Is that what you want me to say? I mean, I just told you. She told me to go get her some medicine.
Okay. All right, Mr.
Can't-
Johnson.
I just said because you know what? I don't mean to be rude, Your Honor, but he's like he's like trying to trick me or something. But I don't know if he paid attention or not, because he's asking like the same questions. And I don't want to be rude or nothing, but I don't.
Okay,
I don't.
so you do not have a note. Is that what you're saying right now? You do
Your
not
Honor,
have one
if
on
I,
you.
I'm going to object at this point
Okay.
for facts not in evidence.
Awesome.
There was no note that was actually presented in evidence prior to
This
trial
is
and discovery.
correct.
So
Right, and this does help prosecution.
What does that? There was no note.
Yes, Your Honor.
Okay, so the
Can I
objection
ask him a
is-
question?
No, the objection is sustained. Mr. Blackstone, do you have any more questions? Objection is overruled.
see.
Do you have any more questions?
Yes, just one more.
Tired.
Looking at exhibits D3A and D3B, did you plant those highlighted plants?
Probably one or two of the basil plants.
I'm asking you, Mr. Johnson, did you plant the highlighted plants? It's a yes or no.
Yeah, I just answered the question. I said one or two of the basil plants. I didn't plant all of them. Those shits was there already.
Okay. No further questions, Your Honor.
I have a question for him.
No,
Can I-
you
can I-
don't. No, you don't.
Excuse.
Oh, I can't. Okay.
No, you're
When
now
is-
being cross-examined, re-examined
When-
by your
when
defendant.
is- when is my turn?
You do
When
not
is it
have a
my turn?
Would you like contempt of court, which is more than all of the charges put together?
I just thought I'd get a turn. I'm sorry. No,
No.
I'll be quiet.
Mr. Johnson, you were asked a series of questions a moment ago. We also touched on Dave Chappelle very briefly.
Good show.
Sorry, what did you say?
I said it's a good show.
Oh, okay. What's your favorite episode from the show?
Objection, Your Honor. The relevance to this. What
is
does this
the
have to do with any of the
rebuttal here?
charges?
It's not at all customary to my case. I was just asking the question.
Tyrone Biggins.
It was just chit chat. All right, to the point, to the question.
Okay, so let's talk about a couple things. Firstly, you were asked a couple questions about which pharmacy you decided to go to.
Yes.
To your knowledge, there's no law stating that you have to go to a pharmacy up in Toledo, right?
No.
You can go to any pharmacy you want.
That's America for you. Go anywhere you want.
Right.
Except for Canada or Mexico.
What?
You can go to any pharmacy except for Canada and Mexico.
Oh, okay. You were asked a couple questions about the first name, or sorry, I apologize, last name of Miss Mary.
Uh-huh.
Is it common for you to refer to people by their last name?
No. Miss Mary, that's a polite thing to do, right? Like Mr. Hunter, right? If you don't really know them, you're not friends and family, then they miss. I mean, and if they're older than you, they miss all of automatically.
Sure. You were also asked a question about you telling Officer Gates that you were going to punch him or something along those lines. I'm not going to ask you to go back through the exhibits.
Thank you, sir. Thank
To
you.
your knowledge, from when you did watch it, did you actually throw a swing or in any way be an actual threat?
I know better. That's just more charges. You go more jail time. That's jail time I can't do because I could be looking for phones and selling them.
So, under the letter of the law, to be charged with assault, there has to be a threat or an action. So he's stating that there's a threat, but there also has to be a present ability to cause the harm. So, my question is to you is, with what they're stating, do you believe that you had the ability with everything that you had around you to cause the actual harm, or did you ever try to?
No, I didn't try at all. I mean, me punching him, what that's gonna give me? That's another guy outside ready to shoot me.
Okay.
So it's a lose-lose. Ain't no point of hitting him.
You were asked a couple questions about you not having a driver's license on you at the time of the incident. You've kind of been listening along to the trial. At any point during the course of the trial, has the state showed that you did not have a license on you at the time of the incident?
No.
Right.
No, they didn't. I don't even have points on my license.
You'd even agree that through the testimony of Officer, I don't recall, I believe it was Officer Steele, he solely testified to the fact that he only took photos of the crucial pieces of evidence, right?
Mm-hmm.
Right. And in those photos that he took, he only took photos of a couple drugs and weapons, drugs and phones.
Yeah, that wasn't my pocket. I mean, the phone is mine. I don't know about those drugs. And that hunting knife is definitely mine. And that crack, that I don't know where that came from. That wasn't even my pocket. Because you would have seen them pumpkin seeds and all that shit in there. And a lot of repair kits, too. And like I said before, I sell repair kits and phones, you know.
Sure. What the prosecutors are alleging is that you planted marijuana plants in the median of the freeway. And again, to your knowledge, what was it that you actually planted on the freeway?
Let the record show for the 18th time, I said basil plants.
Right. I'm just going to finish off so we're not here all night. You were asked a question about a note to drive a car. Have you ever been given a note to drive somebody else's car?
No, I don't. I mean, no, I never got a note before. It's kind of odd to say, hey, give me a note before I drive your car.
Right. They typically just give you the keys as long as you have insurance, you know.
Your license, yeah.
You're covered, right?
Yep.
I have no further questions. Thank you, Your Honor. Thank you, Mr. Johnson.
All right, Mr. Johnson, you may go sit down with your lawyers at this time, please.
Okay, is there any way I can get a seat like this at my chair, at my table?
I do believe you've got some nice ergonomic chairs there, which are great for your back and your posture.
That one's nice and comfortable, though. I can almost fall asleep.
All right, we're going to proceed to closing. No, you have another
God bless, sir.
statement?
Your Honor,
yes.
the defense has a motion it'd like to
Oh,
present.
a motion.
Oh,
Fantastic.
they want me back. They want me back up here.
No, you go over there.
You should come over here.
Yeah.
I don't. Okay.
Your Honor, the
God
defense
bless
would
you,
file a motion to dismiss at this time. As we previously heard from Detective Landmark's testimony, there is a Brady violation that has occurred in this case. The detective and the prosecutors had access to evidence that was exculpatory evidence of what the plants actually were in the median of the highway. And that was never turned over or entered into the evidence or turned over to the defense. So we'd request that this case be dismissed based on that Brady violation.
Your Honor, may I rebuttal to that?
Yes, you may.
In order for the Brady rule to be effective, the prosecution must have possession of that evidence to withhold it. If the police have possession of that evidence, that is not a violation of the Brady rule. If I do not have that evidence, it is not a Brady rule violation. That falls under the problem of the police. Your Honor, that is not a Brady rule violation because I do not have that evidence. And I could even have the courts look at the DA's office, at the pre-filing, and I could even present the defense proof that I had no access to that. So with that in mind, Your Honor, that is not a Brady rule violation as what the defense is trying to convey or bring to you.
Okay, Miss Defense, did you have something?
Can I ask her a question?
You need to speak up, and Mr. Hall, you need to get that spider off your shoe before your defendant freaks out. There we go. Nope, don't freak out that far.
Mr. Johnson, why don't you...
Nope,
Mr.
no,
Johnson,
Mr. Johnson.
Come sit back down.
Do
all
not
right?
leave this room.
All right, come sit down. All right.
Okay, do you have anything else you want to add, Defense?
Sit down for now. Just sit down for now. All right.
You sit down for a minute. We switch your response.
Yeah.
Then we'll talk to you. Don't worry.
Anything else to add, Defense?
Oh, you want me to talk? All right.
Just quickly, yes.
Sorry, you said take as long as I need.
Sure.
With regard to the prosecutor's point, of course, the Supreme Court established in Maryland that they have to turn over all exculpatory evidence. Of course, the officer's not turning that evidence over to the prosecution. does not necessarily make the rest of the evidence just per se, for example. It's still the duty of the prosecutors as well as the law enforcement to turn over any evidence which may be considered exculpatory to the defendant to protect his due process rights.
May I rebut to that, Your Honor?
Yes, for you. Yes, you may. For 1 second. Go ahead.
Let it also be a reminder, as by the former Chief Justice, that if such Supreme Court decisions are brought up, they must be noted in the case laws in the state of San Andreas. If they are outside of the state of San Andreas and they're trying to be attempted to be brought in, they are to be swiftly dismissed. So the reference of Brady versus Maryland is currently irrelevant and not worthy of being brought up in this state until it has been brought up in the case proposals and been accepted by the Supreme Court of the state of San Andreas.
Briefly, Your Honor? Briefly?
Yes.
For starters, Brady was a branch off of Giglio, which Giglio is recognized in the state. Furthermore, the Chief Justice went over stating with the judges that case laws can be referenced. They still can be used as a reference. However, you solely can't state because of this ruling, but you can still use that as a reference to make your ruling.
Correct.
Your
You can
Honor-
use it as a reference. Yes.
Overall, in this case, whether or not we're referencing Brady, this is a due process violation, which is still an argument we're trying to make. The lack of handing over of exculpatory evidence, whether or not it falls under Brady, still is a due process violation, and that in and of itself should be considered by the court.
Okay. So enough. Enough. I've got it. Okay. So in regard to your motion, in regard to the Brady violation, I'm actually going to overrule it at this time. I do believe that from what I have heard today, that the prosecutor did not know that Mr. Landmark did have those plants on him, and he did not submit those. I do believe that is something internal that they will discuss themselves. Right now, we're going to move forward to closing statements.
Thank you, Your Honor.
All right, Mr. Blackstone, if you will, please, the floor is yours to do whatever it is you need to do.
Okay, I'm going to first try to squeeze past these chairs.
Yep.
There we go. All right, free to move about, Your Honor. Permission to freely move about.
Yes, dramatic effect. Go for it.
Yes, Your Honor. Although I'm not going to move too much because of college, my knees are not as when I was young. Your Honor and ladies and gentlemen of the court, today, given the testimonies of Captain Steele and Detective Landmark, we have clearly, without a shadow of a doubt, by their expertise and knowledge in how to apprehend drugs and knowing the knowledge and how to identifying those plants, regardless if they're scientific as what the defense is trying to misconstrue or misconvey to the courts to make them believe that they're incompetent in not knowing how to identify plants and trying to put in question their profession, which is a major insult to the law enforcement when their job is to apprehend drugs. Given with that, those two key witnesses in this have both testified that is marijuana at that divider. Also, to top that, the defense was trying to go with this roundabout by saying it was surrendered not in his property. However, when we look at note 26 in the penal code, it doesn't say it has to be on someone's property. It says it has to be on their property when it references the charge of cultivation. And again, if the defenses were to read that, they would see it says if it was 5 or more plants. Now then, given with the testimony of Landmark, who said he saw him plant 4 plants, the defendant says he planted 1 or 2. Now that clearly is not what is being seen on the body cam of D1, so which means the word of Landmark matches more than what the defendant said. Furthermore, in regards to this, to prove that a car is not stolen, there must be some proof that permission was given, as what he had said and stated, that there was a note, and this is in reference to D1 in the notation. D1, he said that the car belonged to a Mary Supin, and that he told him that the note and contact information for Ms. Supin was in his vehicle, or in the vehicle, which was, what turned out from the statement of Landmark, is a white Buffalo S sedan. It was shown in the evidence at 3 minutes 51 seconds that Captain Steele, the now Captain Steele, searched through the vehicle and found no driver's license and no paper. Now, given with what the law says, when it says operating a vehicle without a valid driver's license, without, we must take this into consideration what it grammatically means. Without, not in possession, not on your person. That is what it is stating, and that is what the state has charged him with. He did not have it on his person. It is irrelevant if it is on his record or not, whether he has a license. It is, for the fact is, it is up to the gentleman to prove he has the license on his person. And given with the testimony of Officer Steele, they searched him, he had no license. And also, to back that up, that, let's see here, at 30 minutes, 9 seconds, 30 minutes, 16 seconds, Gates searches him, no license, as what Gates said in Exhibit D1. And that is evident. Also, to state further in regards to looking at the charges, when the gentleman ran towards his vehicle as Officer Gates was trying to detain him, that is resisting arrest. When he got in the vehicle and decided to drive northbound on the freeway, that was felony evading on foot, as noted by both Captain Steele and Landmark. By their professional opinion and knowledge of what they have as officers, that was felony evading in a vehicle. In regards to that, I asked them both the same thing about the resisting arrest, or I asked at least Captain Steele what if that was resisting arrest. He said yes. Now then, going forward here, with him driving off-road, driving erratic, regardless of what in reckless endangerment. Reckless endangerment means it does not have to pertain to others. It pertains to even himself. So if he was recklessly endangering anyone, he was recklessly endangering himself, including the locals, as what the defense was trying to prevent the officer from trying to state that there was a local vehicle. The defense was trying to stop the officer from stating a vehicle was there, so there was endangerment even to that local. Regardless if it's on dirt roads or not, it is still reckless endangerment. He is recklessly endangering himself, not to mention he's driving off-road in a vehicle that is street-worthy and hasn't been determined to be off-road worthy, even though that's not their professional opinion. However, regarding that, driving around and then eventually stopping and getting out on foot, by the professional opinion of both officers, that is fleeing and eluding on foot. And because of that, and because he was told by Captain Steele's testimony multiple times to stop and he refused, it resulted in him having to be incapacitated and taken back to Sandy Shore to be processed. While in processing, well, actually, let me go back to the vehicle. Because the vehicle had no note on it, and because there's no notation and given with Exhibit C, it is clearly shown here without the notation from quote-unquote Mary Supin, or Miss Mary, as the defendant here in the court has stated her name is. It is proven that this is not her vehicle, or else it would say on the MDT it's her vehicle, but it's not. So which means, by definition of the law, it's possession of a stolen vehicle. because the vehicle did not belong to him, and since you can't charge someone for breaking into a vehicle without being witnessed with Grand Theft Auto, the default charge is possession of stolen property, because if it is, even if it's not reported, but it is not in his name, that is stolen property until he can prove it, which he lied and said he could prove it. So he lied to the officers when he said he had a note. And further the fact, and let's see here, and then going on with the plants, weed. It was noted by all the officers that's weed. Regardless if the defendant doesn't know if it's weed or not, his ignorance is not an excuse, for the fact is he planted marijuana, given by the expert testimony of both officers. That falls under the possession of illegal contraband as defined by Note 26, since drug cultivation can't be charged with him with planting less than 5 plants. Now, in regards to that, going back to the cells there when they searched him, it was noted there that Officer Gates searched him, and then Officer Gates at 39 minutes 6 seconds, he gave Captain Steele what he found on the defendant, which was 2 crack pipes and a few phones. Regardless of what other items were on him, it was the fact is that what was illegal was noted. For the fact is, I don't know where these pumpkin seeds came from. It was never brought up in evidence. It was never used in evidence. We're only going off the word of a person who said that there was pumpkin seeds. However, the defense has not proven that the defendant had possession of pumpkin seeds. In regards to that, because of that information here and going on for the cells, for the fact is that when the defendant was detained and was in the cells, but the fact is, regardless of his arachnophobia, because he made attempts and then twice ran out of the cells, he didn't just stay, he said he stayed at the door. However, as given by the evidence in the body cam, and let's see here, that would be, let's see, what would be that time on that? 34 minutes, 6 seconds to 34 minutes, 35 seconds. It's clear that he did not stay by the door as what he said. He fled from the cell door, and he proceeded to try to make his way out of the jail cells by going to the inner corridor of Sandy Shore to try to escape. In regards to that, because he was trying to, regardless of what the defense is trying to misconstrue to the courts, it doesn't matter. It doesn't have to be another person he's stopping. It can be himself. He was obstructing himself from being apprehended and processed. That's what the defense fails to understand, is that obstruction of justice can mean yourself. And that even in combining that with him getting in his vehicle, fleeing, and putting the police on a long, approximately 11-minute to 12-minute run around, including his foot pursuit, trying to refuse to be arrested can also not only mean resisting arrest, but is also preventing his apprehension, which is obstruction of justice, as defined by the penal code. The defense may try to misconstrue that and try to make the courts believe that it's not, but given by the definitions of the law, it is. With that in mind, and let's go back to the assault. At 29 minutes, the defendant, even on the stand, admitted he even said he would punch the officer in his face or his bald face. Whatever it was said, he admitted he would hit him. Now, given with it says that it must be coupled with the apparent ability to, I would figure with a reasonable person who was willing to flee officers, run away from officers as much as they could, drive around recklessly endangering themselves and running out of the cells, preventing the officers from apprehending him. And for the fact is that he was refusing to be arrested in the first place. It's the fact is that he had the abilities to do that, what he needed. And because he threatened the officer with that bodily harm, that falls under the assault on a public servant. Again, an action or a threat. coupled with the...
Mr. Blackstone,
Yeah,
so this is supposed to be a closing statement summary. Instead,
Right.
you're going through every single charge with the evidence that we've already heard today.
right.
So far, your closing statement is 8.5 minutes long.
Right, Your Honor. My
So
apologies. I'm
that's okay.
just...
If we could just summarize it, this would be
Right.
fantastic.
Right. My apologies, Your Honor. It's the fact is, it's quite a few charges. I'm trying to make sure it's
Yeah,
conveyed
quite-
to the court
yes,
properly.
Yes.
Overall, given all, looks like 11 charges, given with the testimonies of all witnesses and even the own word of the defendant. He is guilty of all charges, and not to mention with his dishonesty and misquotings, he is also guilty of perjury.
I'm sorry?
Oh, Your Honor,
You
for the
added
fact...
new evidence into your closing statement?
Well, Your Honor, he lied before you when he said he planted 1 or 2, when Landmark said he saw him plant 4.
Your Honor, the
And-
defense, of
Your Honor,
course,
the
would move to
defense-
strike.
Yeah, you cannot add something new into a closing statement.
Well, Your Honor, it's... Okay, well, I did state that he did lie before the courts, but...
Your Honor,
However,
the defense
it's...
would move.
However,
The defense would move for a mistrial. That statement was highly prejudicial to the defendant, and we would submit to this court violates his right to a fair and impartial trial.
Mm-hmm.
Your Honor,
Yes.
I was just quoting what was stated in the court, and I was just stating that I will be willing to withdraw what I said about charging with perjury, and have that withdrawn, stricken from the record.
Yeah. So
But-
If I may.
a closing statement should never include any new charges, any new evidence, and definitely nothing prejudicial. So I understand that defense would like to motion to dismiss this.
Mistrial.
Yeah, for mistrial. However, we're so close at this time. Unfortunately, Mr. Blackstone, I'm going to be striking your closing statement because of what you said, and I'm going to be moving forward to the defense's closing statement.
You're striking my entire closing?
Well, most of it was a return to the evidence that has already been set out already in the court case.
But isn't that what a closing is supposed to be, to wrap up whatever was going on and to prove without a shadow of a doubt?
So I'm not going to give you a choice here, because I've already made the choice for you as the judge. But my choices could be to go ahead and dismiss the case because of what you added to your closing statement, or to strike your closing statement. And so I believe that I'm making the right choice in striking your closing statement because of the statement that was made within it, and to move forward with the case.
Your Honor, the defense would still move for mistrial.
Denied at this point. I understand. However, a lot of evidence was brought forward in this case, and I believe that we are going to go to your closing statement.
All right, Your Honor.
Got this.
Your Honor, ladies and gentlemen of the court, I'd like to remind everyone that in law, in the United States of America, it is on the prosecutors, the state of San Andreas, to prove beyond a reasonable doubt that the defendant is guilty as charged for the crimes which Mr. Johnson is charged with. Now, today, there is a severe lack of proving beyond a reasonable doubt of a multitude of charges. Now, first and foremost, we heard a multitude of discrepancies with the charges of illegal contraband and drug paraphernalia. First and foremost, we've already heard that evidence has been withheld from the defense. We've heard that scientific tests were not ran on the plants that were allegedly planted in this median of the highway. We've heard how there is not a true conclusion as to what these plants were, whether this was actually marijuana or not. We've heard this from the testimony of the officers, and we've heard it from the body cam itself. Overall, there is not enough to show that this was marijuana, and therefore it is a reasonable doubt that it was. Now, of course, secondly, pretty clear lackluster in terms of evidence that was presented. There is not enough evidence to show that the defendant actually stole the vehicle that he was in. Now, there is evidence presented that actually the owner of the vehicle was gave permission of the defendant to drive the vehicle. There were statements from officers, their testimony, that stated that they could not definitively say whether the vehicle was or was not stolen. There was not evidence in terms of dispatch calls entered onto the record that actually show that the vehicle was reported stolen, especially on the MDT. Nothing on the MDT as to who the vehicle was registered to or whether or not it was stolen. Therefore, this all amounts to a reasonable doubt that this vehicle was stolen, and the defendant should be found not guilty of that charge. Now, there was also evidence presented, mainly through the testimony of Officer Steele, that the defendant, one, was in possession of illicit material, and two, as to how he was driving. Now, overall, while he was on the stand, we heard the discrepancies in the testimony of Officer Steele. We heard how Officer Steele, he couldn't remember certain things. His job had burdened him with things he was more concerned with in this case than what happened on the date in question. Now, all of that amounts to questionability in terms of the testimony of Officer Steele. We cannot be so certain that what Officer Steele testified to was the truth or what actually happened. He testified himself, admitted that his memory was not what it should have been. He could not remember all that was actually on the defendant. So his testimony as to the search of the defendant should be disregarded as unreliable, overall, and not credible testimony because of his memory. Now, we heard about how there was an alleged assault that took place. Now, in this state, an assault is any action that threatens physically, the threat of physical, unwanted force against another person. Essentially, that equates to a person using their fists, using their body to threaten an unwanted physical contact. Now, in this case, a verbal physical threat, that does not equate to an actual physical assault. Again, just because the defendant may or may not have stated that he was going to come after an officer or whatever he said, does not make it an assault. The defendant, my understanding, was handcuffed, was in his cell, was of no reasonable threat to the officers on scene, and therefore this was not an assault. Now, there's testimony again from Officer Steele as to how the defendant was driving. Now, overall, again, his testimony should, for the most part, be disregarded. Again, he can't necessarily say for certain how the defendant was driving. He didn't provide any evidence as to the speed in which the defendant was driving. Only that he was driving fast, quote unquote. Only that he was driving recklessly. But he never specified what evidence showed that this was a case of reckless driving, or that the defendant in any way was a threat to others around him. Now, finally, I think the most clear case of a lack of any sort of evidence or reasoning for charges of the obstruction of justice charge that was pressed against the defendant. Now, overall, when it comes to obstruction of justice, one party must hinder the apprehension, conviction, or discovery of evidence of another party. Now, in this case, the testimony that we've heard, this was not a case of obstruction of justice. The defendant was already in custody of law enforcement. There was no way for him to be in custody a second time. Again, Officer Steele himself stated that the defendant was placed under arrest. Because the defendant was placed under arrest at that time, no matter what actions may have taken place, there was no hindrance of any sort of apprehension or discovery of new evidence or of a new conviction or arrest. Simply put, In order for a defendant to be convicted of obstruction of justice, they must be obstructing an officer, specifically a federal officer, of their duties of another party, not just himself. And let's say for a second that it was. This law does encompass defendants that do quote-unquote obstruct themselves. It would only be for a defendant that was not in custody. In this case, we know from the testimony that at the time that this obstruction of justice charge was pressed, that the defendant was actually in custody. There is no way that he could have obstructed himself. With that, Your Honor, I think overall, and as I previously stated, the lack of any sort of evidence that would amount to beyond a reasonable doubt for really any of these charges would lead this court to find the defendant not guilty on all charges. Thank you, Your Honor.
Thank you, prosecution. Thank you, defense. I'm going to take a 2-minute recess. I'll be right back with the verdict.
I'm not guilty.
She has to imagine that show with today's day.
I know. Hey, guys, everyone stand up. The judge is here, all right? Put your
All
shirt back on.
rise.
All right?
Yes, sir.
All right, ladies and gentlemen, you may be seated. Defendant, you may stay standing, please.
Who's the defendant?
That's you, Mr. Johnson.
Oh, I'm Henry Johnson.
That's correct. First of all, thank you for all those that have stuck around for the last 3 hours. It's very brave of you. All right, we will be going through the charges one by one. The initial charges were 1 times felony evading law enforcement in a vehicle, which is staying. You also had 1 times reckless driving, which was dropped by the prosecution, and you had 1 times resisting arrest and 1 times drug cultivation, which is also dropped by the prosecution. So, in regard to the felony evading law enforcement in a vehicle, you are found guilty. In regard to resisting arrest, you are found guilty. Now we will move on to the additional charges that were placed by the District Attorney's Office. I'm going to start with the operating a motor vehicle without a valid driver's license. I understand that we have an extensive police force in the city that deal with all sorts of people from different walks of life. I myself have been pulled over by a wonderful law enforcement, and I would have to say that they are very polite, and the person that was driving did not have their license on them. At this point, in regard to operating a motor vehicle without a valid driver's license, I'm going to find you not guilty only because a lot of officers in the city do allow you to either go and get your license or to find your license, or to even they take you very nicely to City Hall to get a license. So that's usually called a fix-it ticket. So at this point, not guilty on operating a motor vehicle without a driver's license. However, we will move on to fleeing, eluding a law enforcement officer on foot. You are found guilty, sir. In regard to illegal possession of drug paraphernalia, is he passed out?
Sorry, Your Honor. Sorry.
I think he's very excited, Your Honor.
Okay. In regard to illegal possession of drug paraphernalia, this is a very interesting charge because it's also been charged along with possession of illegal contraband. There was verbal and eyewitness testimony that showed that you did have crack pipes on you at the time. So at this point, I am going to be charging you with illegal contraband. So you are guilty of illegal contraband. But just one moment. Are you okay? Do you need help?
I just keep going. These guys are going to explain everything to me when you're done.
All right.
Take a seat.
Fantastic. In regard to illegal possession of drug paraphernalia, you are found guilty. Here's an interesting one. In regard to possession of stolen property, you are not guilty. That is because this is the incorrect charge. In regard to reckless endangerment, sir, you are found guilty. In regard to assault on a public servant, I also watched the body cam as well as many others here did. You are found not guilty. I am willing to talk to anyone about that. In regard to obstruction of justice, after thoroughly reading the description of this and looking back at other case precedents, Mr. Johnson, you are found not guilty of obstruction of justice. So, when I go ahead and iron out all of the charges, today you are going to be charged with, you've served 55 months. I believe you were fined for the first 4 charges. After I've done all the math, not the meth, you will be charged today. The difference is an additional 10 months in Bolingbroke Penitentiary and an additional charge of $950. So at this time, court
Your Honor,
is
we would move for a sentencing hearing.
a sentencing hearing
Yes, Your Honor.
right now.
Yes, Your Honor.
Oh
Can
boy,
I do a victim impact speech? I seen that on Law and Order.
that is on Law and Order. You're right.
Okay, I'm sorry.
That's fine. In regard to sentencing, prosecution, since we're moving forward, do you have anything that you'd like to add?
Given with the information here, Your Honor, full-time, full fine.
And defense?
Your Honor, overall, I believe the defendant would like to address the court after I make this statement. But the defense would assert that the defendant should be remanded into the custody. Apologies. He should be issued a sentence of time served, as well as the fine, of course, that he is needing to serve here. Overall, in terms of this case, I think the defendant has already served the appropriate amount of time previously, as to what was originally served from the 4 original, the 4 or 5 original charges. In addition, in terms of this case, the defendant has a pretty minimal criminal record. Overall, he is not poised to be a repeat offender if he is given leniency today. Finally, I think what the court should address and consider during sentencing is the violation of rights that has taken place in this trial. Overall, what's happened in this case, the defendant has not been given the proper evidence, and prejudicial remarks, prosecution in this case. Overall, that amounted to an unfair trial. And because of that, the defendant should get a reduction in his sentence.
Your Honor, may I rebut that?
No, you already said stuff. My turn.
It's not your turn, Mr. Johnson, because I would like to sleep at some point today. What do you, Mr. Blackstone?
If I recall, Your Honor, you struck my closing statement, out of which the defense has no right to use anything that I said in this trial, means you struck it. And
In this sentencing, you are correct.
Your Honor, I believe the defendant would like to address the court.
Your Honor, our objection was still noted on the record that it was unduly prejudicial, and that was potentially on the grounds of a mistrial, but due to the fact that the trial was essentially over, a mistrial wasn't declared.
This is correct. Mr. Johnson, did you want to say something before I give
Yes.
the final sentence?
Okay.
Okay, wonderful.
Ladies and gentlemen of the court, all right, I just want to say thank you. These 2 lawyers did an awesome job. You did too, sir, over here, even though you wanted me to go to jail. Ma'am, I'm an
Yes.
honest man, okay?
Uh-huh.
I don't do something you call proud work. You know, I do odd jobs. I sell phones. I look in garbage, sell repair kits. All right, sometimes some used wine, but it's still good. Maybe some silverware, okay? A deer jumped out and hit me. I felt sorry for it, and I did the right thing, right? I called 911, and I reported it, but in turn, it turned into this big mistake I did in my life, okay? And I'm sorry. You know, I stopped drinking for 5 days. You want to see my 5-day chip? I'll show you after
No,
after
I'm
court.
good. I'm good. Thank you.
And I want to thank everyone from the service, but I am not a liar. I do not do drugs. They don't have any evidence of drugs. I am a good person, okay? Small mistakes here. Now my record is tarnished. Now I got to get an expungement so I can be a lawyer. And I'm sorry for everything that's happened and how long it took. You know, but please, ma'am, you look pretty today. And I got my best suit on. Please, with your nice heart, cut me a small break. And I left a repair kit in there for you, you know, because I'm an honest man. Nothing's free in life. Yes, that's all.
Your Honor, if I may, just one brief comment.
Yes.
As an alternative sentence, this court could also sentence Mr. Johnson to just do some volunteer work with the public defender's office, as that was an interest of his.
Wonderful. Okay. So since the difference in time of the charges that were dropped and the charges that were added is
Thank you,
only
Your Honor.
an additional 10 months. However, the fine is rather substantial. The difference, once I do all the math, is actually $2,950. So, at this time, I am going to. Where did he go? He's gone again.
I'm sorry. I'm sorry. I
Okay,
gotta sell
yep.
a lot of phones and repair kits in order to make that money.
Yes, you do. And you will. You'll have to get a job, sir. So at this time, I'm going to say for sentencing that we will call it time served. However, in regard to your fine, sir, today you will be fined $2,950. But your time will not be charged. You will not be going to Bolingbrook today. I will put that down as time served, and that will be the sentencing for this case.
Thank God. There's a man in there I met named Janiqua, and he made me hold his pocket.
Thank
know,
you, Your
and-
Honor. Thank you.
Okay, wonderful. All right, so the bailiff will be charging you the $2,950 today.
Where's he at?
He's the man right in front of you with the vest on. Yep.
I don't-
All right, court is adjourned. Ladies and gentlemen, thank you so much for being here today.
Okay,
Thank you, Your
thank
Honor.
you. Thank you.
Mr. Blackstone, until next time.